When labor dispute over bonus issue arise and how to resolve. Employment bonus promise could help drive the performance for the business, but sometimes disputes arise because there is discrepancy in translating how performance is met in the eye of employer and employee. According to the provisions of the Labor Code, the bonus, also known as the other supplement, is one of the main contents of the labor contract. Specifically, bonus is understood as a sum of money paid by an employer to the employees on the basis of annual business results and the level of work performance of employees. When the dispute arises, the employer or the employee could consult with labor dispute lawyers in Vietnam to advise and handle the matter effectively. Bonus regulations of each company must be decided and publicly announced by the employer at the workplace after consultation with the representative organization of the grassroots level employees collective. However, there are companies that do not specify bonus regulations or companies with unclear bonus regulations referring to such generally as based on capability or based on work results without referring to specific key performance indicator (KPI). Such regulations will easily cause labor disputes that each party would need to seek consultancy from labor dispute lawyers in Vietnam. In most of the case, the employee would face disadvantage because the employer will be the one who make the final decision on whether or not the capability or work results are satisfied. A labor dispute means a dispute over rights, obligations, and interests among the parties during the establishment, execution, or termination of labor relation. A dispute between the representative organizations of employees. A dispute over a relationship that is directly relevant to the labor relation. Labor disputes over bonuses can be individual labor disputes or collective labor disputes. The competence authority to settle labor disputes belongs to the labor mediator, the Labor Arbitration Council, and the People's Court. Normally, individual labor disputes or collective labor disputes must go through the mediation procedure of the labor mediator before referring to the court to settle, unless otherwise provided for by law. For individual disputes, in case the conciliation is unsuccessful or either party fails to implement the agreements in the minutes of successful conciliation or the settlement time limit expires, but if the labor conciliator fails to conduct conciliation, each disputing party has the right to request a court or arbitration counsel for settlement. For collective disputes over bonuses, in case the conciliation is unsuccessful or one of the two parties fails to implement the agreements in the minutes of successful conciliation, the parties have the right to request the president of the district-level People's Committee to resolve the dispute. If the parties disagree with the decision of the president of the People's Committee of the district or beyond the time limit, but the president of the People's Committee of the district does not settle, the parties have the right to request the court to settle. In such situation, a litigation lawyer would be engaged to assist for productive result. How labor dispute lawyers in Vietnam could help. Labor dispute lawyers in Vietnam could help from the early stage to draft and review labor contract, labor regulations to be submitted and registered with authority. And lawyers, a law firm in Vietnam, always follow up the labor matters to update clients on regular basis. We help clients overcome cultural barriers and achieve their strategic and financial outcomes while ensuring the best interest rate protection, risk mitigation, and regulatory compliance. And lawyers as lawyers in Ho Chi Minh City, Hanoi, and Da Nang, and will help customers in doing business in Vietnam.